you guys all professors? Oh, good. Thank you for coming. So I'm Professor Chris here, and what we're going to do is have a conversation. You guys are asking questions. Good. It's a long class. Don't go easy. And then I want to try this question. I'll ask the first few, we'll get the conversation going, and then we'll dip into the questions. After we're done, I want to show you this new civil war gallery. Right across the street. It's got augmented reality. It shows you. It's really cool when you point losing my voice. So I'll lay it all out for you when you get over there. This is something brand new, just finished. It's not even totally done, but the augmented reality works really cool. So down the road, this is the kind of thing where like local classes will be able to come and do field trips. And then we have a walking tour with augmented reality at different Civil War sites in Harlem. Okay? So down the road, I think that's something people will do. Welcome to everybody. Thank you for coming. Today is Friday, March 25th, and we're here with Jeffrey Rosen, who's the CEO of the National Constitution Center. We've decided to position this as a conversation about the second founding of the Constitution during the Reconstruction era. I mean, those of you who are here know that this is the 10th anniversary of the House Divided Project, and we're hosting a kind of 3-day conference on Reconstruction because it's the 150th anniversary of Reconstruction. It's a troubled period in American history, but it's an important period. It has a lot of significance for the modern day. And so last night, Eric Foner came here, and he gave a very thought-provoking talk about the significance of Reconstruction in American history. And now Jeffrey Rosen is here, and we're going to talk about the 13th, 14th, and 15th Amendments and do a kind of close reading of them with him. And hopefully involve all of the students here. There are students here from middle school, high school, from college, and we also have an audience online. The Constitution Center is one of our partners of this conference, but so is the Gilder Lehrman Institute of American History. We're streaming this over YouTube, and we have affiliated schools and other participants who are watching online, including Dickinson alums. So, with all that said, I want to begin our conversation just by introducing you to Jeffrey Rosen. He is one of America's kind of leading public intellectuals. He's a law professor at George Washington University, an author of several books. His newest book coming out soon is a biography of Louis Brandeis. American Prophet is a remarkable study of a really important Supreme Court justice. I just talked in my constitutional history class about the importance of Brandeis, arguably one of the 2 or 3 most significant justices in American history. And he is the CEO of the National Constitution Center. It's a palace if you haven't been there. And I wanted to begin our conversation first by just having him describe what the Constitution Center does and why you should visit it. And then I want to talk about this initiative that he's launching from the Constitution Center about the second founding. So, Jeff, first of all, thank you for coming.
Thank you so much. It's such a thrill to be here.
Good. So, what is the National Constitution Center, and what are you trying to do with this place in Philadelphia?
Well, you're absolutely right, Matt, that it is a constitutional palace. Some even call it constitutional Disneyland. But it's more than that. It's a beautiful IMPay building right on Independence Mall, across from Independence Hall, with the most inspiring constitutional views in America, because you can look out and see Independence Hall where the Declaration and the Constitution were drafted. And we have rare copies of the Declaration of Independence, the Constitution, and one of the 12 original copies of the Bill of Rights. And we try in the center to tell the story of how the rights that were promised in the Declaration were implicit in the Constitution and finally codified in the Bill of Rights, but didn't ultimately become part of the Constitution until Lincoln's new birth of freedom and the post-Civil War amendments. But the National Constitution Center is more than the only museum of the US Constitution in America. It's also the only institution in America that has a charter from Congress to disseminate information about the US Constitution on a nonpartisan basis. Imagine that in these polarized times when we can see every day the tremendous division in our public life. Congress during the bicentennial thought that it was important that there should be one place that bring together citizens of all perspectives, liberal, conservative, and everyone in between, to educate Americans and to debate not political questions, but constitutional questions, so that we can all converge around this one great document of human freedom that unites us, and that is the Constitution. So we're doing that in a whole bunch of really exciting ways that I want to tell you about. Online, we are creating the best interactive Constitution on the web, and I want you to check it out at constitutioncenter.org. We persuaded the heads of the Federalist Society, which is the leading conservative lawyers organization in America, and the American Constitution Society, which is the leading liberal organization, to co-chair an advisory board and to nominate scholars to write about every clause of the Constitution, describing what they agree about and what they disagree about. What an inspiring thing to be able to click onto the 14th Amendment and see the leading liberal and conservative scholars write a 1,000-word statement about the Equal Protection Clause, and every word of that, you know, is something that the left and the right can embrace, and then you can read their separate perspectives. I'm so excited to tell you that the College Board has just agreed to make this the centerpiece of the new AP History and Government exams. We're working with groups like Khan Academy to do videos about this interactive Constitution. We want to bring it to every student in America from 8 to 80. It is that important. You met Louis Brandeis as my hero, and you admire him too. Brandeis, Jefferson, all of these great thinkers believe that constitutional education is crucial. Unless citizens are informed about the Constitution, liberty will perish. So the interactive Constitution is really exciting. And then, I promise I'm going to stop, but when you wind me up and ask me about the Constitution Center, I get very excited.
We have an hour.
No, we're going to talk about the second founding in a moment. But
Yeah.
this model of bringing together the best minds in America from different perspectives is one that we're pursuing on all media platforms. So we've started this great series of podcasts, We the People podcasts. Check them out on iTunes. They're getting 400,000 downloads a month right now. And every week I call up the top liberal and conservative scholar in the country, and we debate the constitutional issue of the week. We just had a great one with 2 federal judges about the meaning of the second founding. We did the Apple versus FBI podcast last week. We talk about post-Citizens United questions involving free speech. It's exciting to see the hunger for constitutional content and civil dialogue. We have debates that are fanning off across the country. We think they're like the Lincoln-Douglas debates and can transform civil dialogue. Just last week I was in San Francisco moderating one of these debates, co-sponsored by the Federalist Society and the Constitution Society, about whether the Constitution protects a right to equal education. We've gone to Boston, New York, and Chicago and other cities. And then we're having programs at the center and around America in this model as well. So it's it's an honor, and I think it's an important task that we have, this great mission to be the place that brings everyone together for constitutional debate and education. We believe that there are good arguments on all sides of these issues. We want to present them to you so you can make up your own mind. And let me just close this opening pitch about the center by saying the second founding initiative is central to it. Should we talk a little bit about that?
Yes, but it's my job to prompt you.
Right.
So why don't we talk about the second founding
Excellent
initiative?
idea, Matt. I think that's really, I'm glad you asked that question.
That would be appropriate right now.
That would be a very good transition. You have this flawless way of sort of moving from one subject to another. The second founding initiative is one of our central efforts over the next 5 years. The phrase the second founding is so resonant. Where does it come from? Well, we mean it to refer to Lincoln's promise in the Gettysburg Address of a new birth of freedom. Lincoln, as you all know, refers, when he's talking about 77 years ago, not to the Constitution, but to the Declaration. And he's suggesting that Jefferson in his Declaration promised that all men are created equal, but it took the Civil War, the bloodiest in American history, 23,000 dead or wounded at Antietam, to make that promise of equality a reality and to have it enshrined in the Constitution by the 13th, 14th, and 15th Amendment, the post-Reconstruction amendments to the Constitution. So those 3 amendments are turning 150 over the next 5 years. This year, 2016, is the 150th anniversary of the proposal of the 14th Amendment in 1866. And the initiative in particular was the great legacy of a very great man and a dear friend of the Constitution Center and the Constitution, who died just recently. His name was Doug Kendall. He was the president and founder of the Constitutional Accountability Center in DC. And the Constitutional Accountability Center and the NCC are working together on this second founding initiative. Doug Kendall thought it was important that Americans know as much about these crucial amendments related to the second founding as they do about the first 10 amendments that make up the Bill of Rights and about the rest of the Constitution. So he gave us this great charge. Go out and do everything you can to provoke debate and education, bring together the best historians from all perspectives, political scientists, scholars, citizens, and students, and inspire a national conversation about the second founding. So with his help, we persuaded Justice Sandra Day O'Connor to chair an advisory board to oversee the second founding initiative. A remarkable series of federal judges have signed up to be on the advisory board, and we're going to bring in scholars and public officials from both sides of the aisle as well. And our job is just to provoke constitutional conversations about the second founding. So on May 10th, I think it is, we're having a 14th Amendment launch at the National Constitution Center with 2 great panels devoted to how judges interpret the 14th Amendment in their classroom and what the 14th Amendment means today. That follows a launch event on the 13th Amendment, which we held at the National Archives at the end of last year, which was right around the time that the 13th Amendment was ratified. And these conversations are going to go on over the next 5 years with podcasts and videos, and we hope with the first exhibit devoted to the constitutional legacy at Reconstruction. Matt, you here at Dickinson and your colleagues are doing such important work to commemorate the Second Founding. I'm so impressed with the interactive exhibit that you've set up about the Second Founding. I'm so grateful that you've worked with the NCC team to create a Second Founding alcove at the museum. And I'm hoping that this conversation we're having today is going to be the beginning of an ongoing collaboration that Dickinson and the NCC have to celebrate and commemorate and debate the meaning of the Second Founding over the next 5 years.
Great, all right, then let's get into it. So Jeff and I were talking beforehand about how there's a difference between the way law professors teach the Constitution and the way historians teach it. They focus on the text, and historians tend to focus on the context and the people more than anything else. And so, since I'm the historian, I'm going to force you to start with the people. If we were going to propose a list of founders of the reconstructed Constitution, the framers of the 13th, 14th, and 15th Amendment, what are some names that you think students of all ages should really know and begin to understand?
Well,
who are the Madison, Jefferson, and Washington of the reconstructed Constitution?
Frederick Douglass, John Bingham, and Thaddeus Stevens, I think.
Okay.
So Frederick Douglass is Washington because it is his vision more than anyone else that the stain of slavery has to be constitutionally eradicated from the Constitution, and that vision is expressed in the 13th Amendment to the Constitution. And John Bingham and Thaddeus Stevens are the Madison and I guess we'd say Hamilton, although it doesn't exactly track. Jefferson is in Paris during the convention, but it's Bingham in the House and Stevens in the Senate, who basically are the James Madison of the Reconstruction Amendment. So just a word on each of them. You know probably more about Thaddeus Stevens, both from the Lincoln movie, where he was played so well by Tommy Lee Jones with that great long hair and you know, very powerful performance. But Stevens both is funding Reconstruction, is insisting on the need for the 13th Amendment, and as we remember from the movie, actually going and amassing the votes for it in the Senate.
In the House. Right. He's the chairman of the House Ways and Means Committee then, yes.
Thanks for that. He's sort of bringing it all together.
Right.
And then Stevens also gets up and says, during the debates over the 14th Amendment, centrally, we have to efface this notion of caste from the Constitution, C-A-S-T-E. He said the Constitution neither has no place for class legislation or for any notion of caste, and that idea is central to the 14th Amendment. And then we have John Bingham, who, if more than anyone else, has got to be the...
Now, let me stop you there.
Yeah.
How many people in this room, raise your hand if you've heard of John Bingham or know enough about him to describe him at all? We've got about, I'd say, 25% of the room. And this is a room of well-educated, sophisticated people, Dickinson students, Dickinson alums, and people who are studying this topic. He's not well known. He's almost totally obscure. And yet you think he's the most important founder of the Second Founding.
He's the James Madison. He's the guy who actually writes the 14th Amendment and has a very specific idea of what he's trying to achieve. He is from Ohio. There's a great new biography of him by Gerald Maglioka, which you can check out if you want to learn more about him. For more than a century, he was dismissed by people like Felix Frankfurter on the Supreme Court, who didn't share Bingham's great vision. Bingham believed that the purpose of the Civil War was to achieve two great constitutional ends. First, he wanted to prohibit the states, as well as the federal government, from denying basic civil rights and privileges and immunities of citizenship. James Madison had initially had a similar vision. The amendment that Madison considered the most important in the entire Bill of Rights that he proposed would have forbade the states as well as the feds from denying rights of conscience, trial by jury, and freedom of the press. But that amendment wasn't passed because Madison's colleagues wanted to bind only Congress, not the states. That's why the First Amendment says Congress shall make no law. It doesn't say the state shall make no law. And initially, only Congress is restrained. But that allowed the states to deny all sorts of basic rights to African Americans. Slavery was a walking violation of all of the rights of the Bill of Rights. Enslaved people were forbidden to have access to to make contracts, to sue and be sued, to have access to the criminal procedure protections of the Bill of Rights. And that's why, for Bingham, the original Constitution itself could have been read to guarantee these basic civil rights to African Americans. And I don't know if this is too technical. This is getting a little wonky, but what the heck, we're talking about Bingham. Let me tell you why he thought that the original Constitution arguably guaranteed these rights, but it took the 14th Amendment to make the protections explicit. So, okay, this is total wonk city, but I'm going to take out my pocket Constitution, which is from the National Constitution Center.
And those of you who have the handout can read along.
You have the handout. This edition has an absolutely riveting introduction by yours truly and David Rubenstein about the relationship between the Constitution, the Declaration, and the Bill of Rights, which you can read online at constitutioncenter.org. But I'm going to begin not with the 14th Amendment.
Okay.
We didn't rehearse this bit, but
Yeah.
it's interesting because we're talking about John Bingham. So let's really dig into his vision. Let's go not to the 14th Amendment, but to what's called the Comity Clause, and that's in Article 4. And we're going to Article 4, and we're going to read the...
Comity, for the students in the room, is C-O-M-I-T-Y. It's the relationship among states.
That's exactly right. And Article 4, Section 2 says, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. What does that mean? That means that if a citizen of, I'm going to say I lived in Maryland, and I go to Virginia, I'm not allowed to vote in Virginia elections, because that's a political right, but I am allowed to make contracts, to sue and be sued, to be entitled to all the basic civil rights of citizenship. Now, Bingham and some other Reconstruction Republicans believed that the basic rights to make contracts and so forth were privileges of United States citizenship that free African Americans should be able to take with them when they traveled to other states. They believed that the Comity Clause should be read as if it contained a kind of ellipsis in it, and essentially said the equivalent of, the citizens of each state shall be entitled to all privileges and immunities of citizens of the United States in the several states. And Bingham believed that United States citizenship carried with it the entitlement to these basic civil rights, and all persons, African American and white alike, were entitled to them. But because that wasn't explicit, and because slavery was an open denial of those rights to African Americans, there was no authority in the Constitution for Congress to punish states that were denying these basic privileges or immunities to African Americans. Also, the infamous Dred Scott decision to the Constitution had said, and it was unfortunately written by an alum of this great university,
Who could that be?
Chief Justice Taney, who, you know, it should be said before...
Class of 1795.
Before his infamous Dred Scott decision, Chief Justice Taney was respected as a truly effective and a very able Chief Justice. He carried on the vision of John Marshall in his nationalism while cutting back a bit on some states' rights. But as the late Justice Scalia observed in his memorable dissenting opinion in Casey versus Planned Parenthood, the stain of Dred Scott has come to overtake Chief Justice Taney's reputation. And Taney said, essentially, the black man has no rights which white men are bound to respect, reading them out of the Constitution, suggesting that even freedmen at the time of the framing had no rights because they were not citizens of the United States. Now, this was ahistorical. At the time of the framing, there were several states that did give free African Americans rights of citizenship, but because citizenship in the original Constitution was defined by your residence in a state, and there was no single provision that created a category, of United States citizenship, these rights were abridged. That's why, and you'll see now the connection between Bingham's theory of the Comity Clause and the post-Civil War amendments, Bingham thinks it's important to overturn the Dred Scott decision several times. And Dred Scott is called the most overturned decision in American history because the 13th, 14th, and 15th Amendments all repudiate it. And we can talk about each of those amendments, but at the risk of really getting into the weeds, it's important to recognize that this great founder, John Bingham, thought that implicitly, if not explicitly, even the original Constitution could be read to give these basic civil rights to all people.
Okay, good. So why don't we do a quick little close reading of the three amendments with Jeff, and then we'll open up the floor to some questions from the audience. I know I have some students here from Crossroads and from Carlisle, and hopefully some from Penn Manor as well. And my own students are here from Dickinson, so we'll see if we can engage a wider conversation in a few minutes. But first, you have your handout. I should note, before we start this close reading, the only person that Jeff didn't mention who's featured on this handout is another Dickinson graduate, John A.J. Cresswell, who is arguably one of the authors or founders of the 13th Amendment. He led the debates for the 13th Amendment, and at the House Divided Project, we've just issued a new ebook about Cresswell called Forgotten Abolitionists. He's truly forgotten. And it's written by John Osborne, who's an emeritus professor here and co-founder of this project, and Chris Bombaro, who's the associate director of the library. It's free, and I would urge all of you to go to Smashwords and download it. It's a really good, interesting read about a man who was from a slaveholding state who became an abolitionist because of the Civil War. So the 13th Amendment, I only have the first section of it listed on this handout. This is actually the teaching handout that I use in many of my classrooms. So Jeff, will you walk us through this first section? The second section is just about congressional enforcement, but the first section has some particular or peculiar words, and I wanted to see if you could explain to us where they come from and what they mean.
Great, let's read it. Neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. All right, let's parse this amendment. First of all, why was it necessary? We all know that Lincoln in the Emancipation Proclamation supposedly freed the slaves. So why do we need a constitutional amendment to say that slavery is unconstitutional? Well, first of all, the Emancipation Proclamation was a very careful document. Lincoln was a great constitutional lawyer, and he believed that he only had the power to end slavery within territories under federal military jurisdiction. He didn't think that as commander-in-chief, he had the military power to ban slavery throughout the United States. So that's why he believed that it was important, and we know from the movie Before the End of the War, to ban slavery throughout the entire United States, as well as any place subject to the United States' jurisdiction, and to give Congress the power to enforce that amendment by appropriate legislation. What does or any place subject to their jurisdiction mean? Well, there were parts of the United States, including those controlled that were then called Indian reservations, that were subject to the jurisdiction of the United States, but legally considered separate from them, so it certainly meant to cover that, as well as territories abroad, and those were covered as well. So the 13th Amendment is unequivocal in banning slavery in any place subject to the jurisdiction of the United States. Then why does it say neither slavery nor involuntary servitude? Well, there was concern about peonage, which is a kind of slavery by another name, where either freedmen or others were subject to forced labor contracts and treated as slaves and denied basic civil rights, like the right to sue and be sued and to inherit property, slaves in all but name. And that's why the 14th Amendment doesn't only ban chattel slavery, but also involuntary servitude. And then why does it contain that exception about punishment for crime? Well, obviously involuntary servitude could be read to include a prison sentence, and that is legitimate if it's a sentence imposed according to constitutional requirements of due process of law, but that's the only circumstance under which someone can be subject to involuntary servitude. So that's why this language is chosen very carefully. Note all the things that it doesn't do. It doesn't guarantee civil rights or privileges or immunities to African Americans, and it doesn't guarantee voting rights to African Americans. It took the 14th and 15th Amendments to do that. That's because when the 13th Amendment was passed, this was the most that the Thaddeus Stevens and John Bingham believed could get through Congress, and that's precisely why they chose the language they did and why it passed.
Good. So two things. So first, as a historian, I also just want to add the language of the 13th Amendment draws its origins in part from the Northwest Ordinance from 1787. And so that is one of the important connections that all students should try to remember. And second, last night, Eric Foner said some terrible things about the Lincoln movie.
He doesn't like it.
He mocked Hollywood and the way they approach history. He said it's good fiction. But I would think that you have a more positive impression of the movie because I cannot think of a movie that tries to take a constitutional moment as seriously as that movie. And I wanted to see if you would comment on the movie as a CEO of the Constitution Center. I mean, how do you view it? And with the proviso that Eric ridiculed it.
Eric Foner came to the Constitution Center and ridiculed it as well.
Yeah.
I interviewed him.
He actually said, I don't know if he said this in Philadelphia, but he said Lincoln the Vampire Slayer was a better movie.
Well, Eric Foner is the greatest historian of Reconstruction in America, and I will defer to his movie tastes in general. I have to say, as a movie goer and constitutional educator, I certainly think it did a great job at connecting the history to students of all ages, in the same way that Hamilton, the musical, just does such an inspiring way of bringing the founding to life. I could have done with a little less of the unnecessary fictions, like pretending that the vote was closer than it was. There's no need. It was dramatic enough to tell the story without changing the actual votes. But broadly, I sympathize with the urge and love the idea. Isn't it exciting to see how dramatic it was? This is a constitutional story. It was also a political story. And the fact that it was a cliffhanger, and we see how much log rolling and ordinary politics and quid pro quo compromise was necessary, reminds us that constitutional politics doesn't take place in a vacuum. It's against the background of real politics. The founding itself was the same thing. The infamous compromise, the Connecticut, both the Connecticut Compromise, which strikes a balance between large and small states, and also allows slavery to continue in the southern states, and says it can't be, banned until 1808. This is a stain on the founding, but it's also what allowed the Constitution to be passed. So seeing the Reconstruction founders, the second founders, and the first founders as practical politicians who got together and saw the necessity of compromise is something very important. It's a lesson we could use today. Sure. And for all those reasons, I like the movie.
So before we go to the 14th Amendment, and understanding that we'll have time for general questions, is there a student who has a question about the 13th Amendment that they want to ask? I have two interns in the back, Major and Christina, with microphones. I see one question up here, Major. If you could bring the microphone up. Just identify yourself and where you're from, and once the microphone reaches you, and ask away about the 13th Amendment.
Oh, hi. I'm Mace Van from Carlisle High School. I just had a question about the 13th Amendment of why was it so hard for certain subjects in the 13th Amendment to get passed when you just when earlier you said that, this is all that Thaddeus Stevens and Bingham thought that they could do. Why was it so hard for more subjects to get passed within the 13th Amendment if at the time there was a majority of radical Republicans inhabiting the legislature? People of basically more of a same mind than in comparison with other legislators from earlier in American history, because they didn't have like those Southerners also coming in and putting their very different input. So with people of the same mind, why were there only essentially two things to get passed within the 13th Amendment?
That is such a wonderful and important question. That's really a central, great question. And I think the beginning of the answer is that Bingham and Stevens did not have a reliable majority. You call them radical Republicans, Bingham a little bit more moderate than Stevens, but there were plenty of Republicans who were more concerned about preserving their majority in Congress and not being swamped by Democrats admitted from the new southern states than they were with extending equal civil rights and voting rights to African Americans. Remember, Lincoln himself initially said that the purpose of the Civil War was to preserve the Union, not to end slavery. And early on he said, if it takes keeping slavery to preserve the Union, I'll do that. And if we have to end slavery, I'll do that. The point was to end the Union. Now, Lincoln definitely evolved. And by the end of the war, he came to see the effacement of slavery as a moral and constitutional responsibility. But there were other Republicans, more of the moderate mindset, who, although they were willing to accept the idea that slavery itself had to be abolished, were uncomfortable, as their constituents were uncomfortable with the idea of full civil and political rights being extended to African Americans. I think we have to own and acknowledge this less than inspiring part of the story, because it shows what a complicated time politically it was. you can read in even Lincoln, the great emancipator, statements that jar us today and make us uncomfortable. In the Lincoln-Douglas debates and at other times, he expressly disavowed any intention to give African Americans what he called social rights as opposed to civil rights. He said, yes, there should be basic equality of civil rights to make contracts, to sue and be sued, but you can't force white people to invite black people over to their houses and share meals with them. I mean, it kind of has we would call it racist today. But that was the mentality of the time, and you can see how in the minds of even the greatest of the Reconstruction Republicans, like Lincoln, this idea of civil equality can coexist with notions of social subordination that seem to us today unacceptable. That was the political reality. So at the time of the 13th, this was the best that they could get through. The fact that over the next few years, the 14th and most hotly contested of all, the 15th were passed, showed the fact that Congress became increasingly committed to equality for African Americans. The high watermark of Reconstruction was 1875 when the Civil Rights Act was passed, which would have forbade public accommodations from discriminating on the basis of race. That law was infamously struck down by the Supreme Court in the civil rights cases. It took another more than nearly 100 years, the Civil Rights Act of '64, to resurrect that. But just to tee up to sort of close this thinking about the amendments together. So slavery is the least controversial part of the amendments. The 14th Amendment extending equal civil rights, a little bit more so. The most controversial part is voting rights. And when Lincoln vowed, soon before his death to extend political rights and voting rights to African Americans, John Wilkes Booth was in the audience, heard the speech, and basically said that pledge is Lincoln's last. He decided to assassinate Lincoln when he heard Lincoln promising to give African Americans voting rights. So it was a process, and that's just a great question about the bottom line is there was not a political constituency at the very beginning for extending all civil and political rights to African Americans. Thank you for that.
So we've talked a lot about the 13th Amendment in my classes. Is there a Dickinson student who wants to ask a question about the 13th Amendment or about slavery and the abolition of slavery? Is there anyone else who wants to question something specific about the 13th Amendment? All right, then. Let's turn to the big enchilada,
okay.
The 14th Amendment.
Here we go.
And let's just focus on the first section of the 14th Amendment, because that's the key for our present day. And Jeff, why don't you give us a close reading of that, and then we'll ask some questions about it.
Great. Well, you're right. This is the big enchilada. I have the great pleasure of teaching the part of constitutional law that focuses on the 14th Amendment, and we spend an entire semester just parsing these words. All of American constitutional history since the Civil War, so much of it is can be found in an interpretation of this great section. So
we'll give you 7 minutes.
We're going to do the 14th Amendment in 7 minutes, and I love the challenge. Here's the first sentence. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. All right, well, we already know a little bit about this sentence because we talked about the Dred Scott decision, and this sentence is designed to overturn the part of the Dred Scott decision that said that there could be persons born in the United States, such as African Americans, who were neither citizens of the United States nor of the state wherein they reside. This is saying that if you're born in the United States, you are a U.S. citizen and have full access to all the privileges and immunities of U.S. citizenship. It also makes citizenship of the United States primary rather than state citizenship. The big question in Dred Scott was whether when Dred Scott's master took him from one state into free federal territory, he became emancipated. And that was because citizenship at the time depended on which state you were born in and where you were. And this sentence is designed to end that confusion and clearly say there is a category, United States citizenship, that all of us who are born here or are naturalized as U.S. citizenship enjoy, and that contains these basic civil rights or privileges or immunities. There's this odd sentence in the middle that says, and subject to the jurisdiction thereof, language we also saw in the 13th Amendment. What's that referring to? The framers of the 14th Amendment said that means that Indians who are not taxed are not considered citizens. it was a peculiarity, again, a rather jarring one at the time, but Native Americans on reservations at the time were not considered subjects of the jurisdiction of the U.S., and they weren't supposed to get all the privileges or immunities of U.S. citizenship. But that's the gist of the first sentence to overturn Dred Scott.
But other than that quirk applying to Indians, it seems like it's such a plain language statement about birthright citizenship. So how has it become controversial in the present day? I mean, in the presidential campaign, people are challenging the meaning of birthright citizenship.
Well,
How do they do that?
you make me get out my constitutional reading glasses repeatedly, because there's another phrase of the Constitution, and we know it's in Article 2 because it deals with the powers of the presidency. And it says, no person except a natural-born citizen or a citizen of the United States at the time of adoption of this Constitution shall be eligible to the office of president. So let's compare the language. This says you have to be a natural-born citizen to be president, and the 14th Amendment says that you have to be born or naturalized in the United States. And without getting too much into the Ted Cruz question, let me refer you to the great National Constitution Center We the People podcast, where we had a vigorous debate about this. It turns out that there are decent arguments on both sides of this debate, although I won't tell you which I find more persuasive. There was a law, a naturalization law, passed by the first Congress that defines what it takes to be to be naturalized in the United States, and the argument in favor of considering those persons as eligible for president is that if you were naturalized according to this law, you can be considered as if you were a natural-born citizen. The argument on the other side is that even the framers of that first law distinguished between naturalized citizens and natural-born citizens, and natural-born citizens were those who actually were born here rather than naturalized afterward, and therefore Ted Cruz doesn't count. So, but the language is very important here, and it's natural-born citizen is not the same as born or naturalized in the United States. Of course, the other great constitutional controversy in this presidential election that relates to this clause is Donald Trump's suggestion that the children of aliens who are, or of non-citizens who are born in the United States are not citizens if their parents weren't citizens. So he's basically questioning the idea of birthright citizenship and saying if you're the child of parents who are illegally in the United States and you're born in the United States, you shouldn't qualify as a natural-born citizen. Now, the Supreme Court has addressed this issue and ruled against Mr. Trump on this subject. It suggested that...
In which case was that?
I should have it right at hand.
Okay.
But go to the Constitution Center right side. No, good. Yeah. It's a good question.
Are you thinking of the Wong Kim Ark case?
Thank you.
Right.
Yeah.
Okay. So I'm good on the 19th century.
Good.
That's my specialty.
Well, let me interview you about
no.
which side you think
so,
is more
but
persuasive.
that case dates back to the 1890s.
It does.
Right. And it's still the law of the land? It's still the guiding Supreme Court interpretation?
There's not been another more significant case since then.
So do you think that means Trump is on weak ground with this claim, or do you think that case law may be outdated?
I'm just going to say something descriptively. So I have the pleasure of heading the nonpartisan National Constitution Center. Right. And the truth is, and I want you to really believe me when I say this, there are good arguments on all sides of any constitutional question, and you will be astonished at how an argument that had been considered outside the mainstream one moment can just very quickly be considered inside the mainstream.
Right.
So courts can do anything and do, not to say that the Constitution is entirely malleable, but I wouldn't rule, I would never suggest this argument is beyond discussion, right. because because ultimately the Constitution is what the courts say.
Does anybody want to ask a follow-up about the birthright citizenship issue? We have a student up here from Carlisle. Make sure you give us your name as well.
I'm Jacob from Carlisle. Because you said it's up for debate, do you think that anything in the Constitution can be up for debate because of that?
That's a great question. I think that anything in the Constitution can and should be debated because the Constitution is a conversation. The Constitution, as Justice Oliver Wendell Holmes said, was made for people of fundamentally differing points of view. So I think that all of us have an obligation to listen respectfully to constitutional arguments, even those that we disagree with, to engage them, and to educate ourselves enough to respond to them. That does not mean that I think that every constitutional argument is as good as every other argument, and that there are no right and wrong answers to the Constitution. The simplest example of a right or wrong answer is the part of Article 2 that says that no person shall be president who has not attained the age of 35 years. If you're 33 years and you are running for president, then the Constitution says you're not eligible. Now, obviously, most provisions are not as crisp as that. And since you asked me, I'll stop being coy here. I think on balance, given the text, history, precedent, structure of the Constitution, I think that those who agree with the Supreme Court that all persons born in the United States are citizens regardless of whether their parents were citizens have the better argument than those who argue the opposite side. But I'm just saying that it's not preposterous to say that the Supreme Court was wrong and everything is worth examining.
Okay, I think we should move to the privileges and immunities clauses and
Yes.
equality and due process.
This is so, first of all, it's so exciting to parse the 14th Amendment because there's so much in here and there's so much to learn. Each of these clauses just has all of the most basic questions of American life are packed into these precious words. So let's read them. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. I'm going to stop right there. This is just crucial. So the first thing to note is those words, no state shall make or enforce any law. John Bingham chose those words very carefully to signal his intention that the states, as well as Congress, can't take away the basic privileges or immunities, which he considered to be equivalent to most of the rights in the original Bill of Rights, as well as other rights that were abridged by the infamous black codes. So when you're reading the Constitution, there's a story behind every provision. There's usually one great event that people are trying to address and to respond to. And here the problem that people are trying to address is that after the war is over, and even after the 13th Amendment is passed, a bunch of southern states passed these infamous codes called the Black Codes, which forbid freedmen from making and enforcing contracts, from suing and being sued, from inheriting real property, basically reducing them to peonage, to which the 13th Amendment is trying to stop. So Congress tries to respond to this by passing the Civil Rights Act of 1866, which says that all persons, white and black alike, are entitled to these basic civil rights of contract and citizenship. But Johnson vetoes the Civil Rights Act, and Congress isn't ultimately positive that it has the constitutional authority to pass the Civil Rights Act in the first place. So in order to put the Civil Rights Act on unimpeachable constitutional ground, Bingham wants to say as clearly as he can that no state shall abridge these privileges or immunities of citizenship. There's an amazing speech where Bingham, a few years after the 14th Amendment is passed, gets up and makes crystal clear his desire to what's called incorporate the Bill of Rights against the states, or forbid the states as well as the federal government from abridging these privileges or immunities. He says, Mr. Speaker, you know, I was writing the 14th Amendment, and I went back to this case where Chief Justice John Marshall said, the Bill of Rights only binds Congress. It was called Barron versus Baltimore. And Bingham says, I read Marshall, and Marshall said, look, if the original founders had wanted to bind the states, they would have used the words, no state shall make any law, the same way as they used the word, no, Congress shall make no law. And Bingham says, Mr. Speaker, emulating the great Chief Justice and taking him at his word, I chose those precise words, no state shall make or enforce, in order to signal my intention that the states as well as Congress are bound. It's this thrilling moment. It's like an aha moment. And what's so exciting about it is it took the Supreme Court almost 100 years between the passage of the 14th Amendment and really the 1960s to read Bingham's words and to fulfill his intentions. And even today, parts of the original Constitution are not incorporated. The Seventh Amendment, the bail provisions of the Eighth.
They really haven't fulfilled his vision, have they? He believed in total incorporation, wouldn't you say? No?
This is up for debate. There's
All right.
Well, you want one bit of wonkery? Look, Matt is really egging us on, but this should, I'm trying to excite you about constitutional
Incorporation
study,
is a really important doctrine.
Really
now,
important.
maybe it's more at the college level and law school level, but
I think you guys are engaged enough. I can tell by your questions and the fact that you're listening to me. You can deal with all this. You don't have to be a law student. Here's the wrinkle about whether all of the Bill of Rights is incorporated against the states or not. There's a great scholar called Akhil Amar at Yale Law School. He was my teacher. He's a fellow of the National Constitution Center. Go read his book, America's Constitution. He's the greatest scholar of Bingham's ideas about incorporation. He said Bingham wanted to incorporate all the parts of the Bill of Rights that had to do with basic privileges or immunities of citizenship that were individual rights, but there were certain parts of the Bill of Rights that were federalism constraints, that were trying to constrain federal power rather than empowering individual rights. And one of those provisions, he says, is the First Amendment's prohibition on Congress from making an establishment of religion. And this is getting really wonky, but it's also kind of fun. Akhil Amar says, at the time of the original Constitution, a bunch of states had established religions like Congregationalism or Unitarianism. And the point of the Establishment Clause was to prevent the feds from disestablishing those state religions by creating a national church. So the Establishment Clause, and I haven't used this word since I studied for the SATs, Akhil says it was an anti-disestablishment provision. In other words, trying to stop Congress from disestablishing the state. So for that reason, he thinks that you can't incorporate the Establishment Clause because it was trying to prohibit Congress from doing something, not empower individuals. Now, Justice Thomas on the US Supreme Court agrees with Akhil Amar on this. He's the only justice who does, and thinks that maybe not all of the Bill of Rights incorporates, but most of it does. That's a wonky but important question about how much of the Bill of Rights incorporates. But the punchline of this, I'm burying the lead on the Privileges or Immunities Clause. You would think that this is the most important part of the whole 14th Amendment because John Bingham carefully chose these words to apply the Bill of Rights against the states. How do you react when I tell you that the Supreme Court in the infamous slaughterhouse cases, soon after the 14th Amendment was ratified, read the Privileges or Immunities Clause out of the Constitution? It construed this clause in a way that emptied it of all meaning and said that there are no basic privileges or immunities of citizenship that are not already spelled out in the original Constitution, like the right to petition Congress or to have suits on the high seas or a bunch of sort of frivolous rights that are already in the structural Constitution. The court read the amendment in a way that refused to recognize Bingham's majestic ambition to bind the states and force them to respect these basic civil rights of citizenship. What the Supreme Court had to do as a result is engage in this act of incorporation through the next clause we're going to read, the Due Process Clause. But the result is that citizens of the United States had to wait almost 100 years before these basic rights of citizenship were actually protected against state infringements. And that's essentially because the Supreme Court was scared that it would change the balance of power too much. In the slaughterhouse case, they said, gosh, if we do this, then the states are going to have their power constrained in a big way. The fact that that was the entire point of the Civil War and that John Bingham and his fellow Reconstruction Republicans thought that was the very purpose of these amendments didn't move those justices. The slaughterhouse cases today are attacked by people on the left and the right as examples of illegitimate judicial activism.
Okay. Listen, I know these last clauses are so important, but let's do a concise, close reading of the Due Process and Equality Clause so we have enough time for the 15th Amendment.
Okay, good.
Okay?
That was a very gentle kind of hook, but I understood.
They're all important,
yes.
And we don't have enough time.
You're right. Well, in that case, let's read them together, even though this is a mouthful and there's a lot here. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. So those are called the Due Process Clauses and the Equal Protection Clause. The first thing we note about those two clauses is that they apply to persons, citizens and non-citizens alike, rather than the Privileges and Immunities Clause, which only applies to citizens. The Due Process Clause, on the most basic level, basically says you can't be taken in jail or have your property taken away without a trial. You've got to have some process that's spelled out in the Constitution. No one disagrees with that. What makes the Due Process Clause controversial is starting in the 19th century. This goes way back. Because remember, the Fifth Amendment to the Constitution, which binds Congress, also has a Due Process Clause that says that Congress can't deprive people of life, liberty, or property without due process. But here, the Supreme Court started to say there are certain liberties that are so fundamental that the states can't take them away even with due process, with a trial. And those liberties include rights recognized in the Progressive Era, like the right to make contracts which was used on a kind of libertarian basis to strike down progressive legislation like maximum hour and minimum wage laws, and then move up to the 20th century, and cases like Roe v. Wade, Planned Parenthood v. Casey, the Obergefell case, all found a basic liberty or autonomy of reproductive choice in Roe v. Wade and Casey, or of the freedom to choose whom you want to marry in the Obergefell case, and it located those rights in the Due Process Clause. I said that's controversial because some critics of that jurisprudence, including the late Justice Scalia, said, hey, the Due Process Clause can't be read to protect substantive rights. It says, although you can't take these rights away without due process, you can take them away with due process, and therefore it makes no sense to say that there are certain liberties that are so important that they can't be deprived under any circumstances. So that's a big debate today, and if you're a textualist, you might agree with Justice Scalia that it seems to refer only to process. The Supreme Court, though, has disagreed, and now in many, many precedents, many justices from different perspectives have said there are certain liberties that are protected. So that's the Due Process Clause. And last but absolutely not least, and probably most important of all, no state can deny to any person within its jurisdiction the equal protection of the laws. Well, my goodness, the core of the Equal Protection Clause vindicates Lincoln's promise at Gettysburg, Jefferson's promise in the Declaration. It says that African Americans in particular can't be denied the protection of the law. What was protection of the law? In the most narrow sense, it was police protection. Reconstruction is a time when marauding Southern mobs are setting on African Americans, engaging in violence against them, and Southern police forces are sitting by idly and denying to African Americans protection of the law against the Ku Klux Klan. So at the very least, in its narrowest sense, the Equal Protection Clause says whatever protection is given to white citizens has to be given to all persons, citizens and aliens alike, regardless of race, creed, or color, and that applies across the board. Now, in the 20th century, the Equal Protection Clause has become perhaps the most important clause of the Constitution. The greatest and most revered case in 20th century history, Brown versus Board of Education, relied on the Equal Protection Clause to strike down school segregation, overturning a decision, Plessy versus Ferguson, that had upheld segregation on railroads nearly a century earlier. Conversely, the infamous Korematsu decision upheld President Roosevelt's internment of Japanese American citizens, saying that that was not a violation of the Equal Protection Clause. So equal protection is hugely important, it is the big guarantee of equality in the Constitution, and it is the fulfillment of the second founding.
So it's the centerpiece of this entire discussion, the 14th Amendment, especially those two clauses. Does anybody want to ask a question about the ramifications of these clauses for the present day? I think Simon over there has a question, Christine. Now, this is one of my students, so this is going to be a tough question.
Oh, okay, I'm sweating it. Be gentle.
So my question is about we talked a little bit about this in class, but the distinction between the person versus citizen application. I know it's particularly relevant today with like prisoners in Guantanamo Bay, which if you read this textually or literally and take person as person, would mean that having such a compound would be unconstitutional. What is your interpretation of that?
Such a great question, important question, and a hard question. I'm going to get wonky because the framers were wonky in the sense of being very careful about the language they chose. So when they're distinguishing between citizens and aliens, they're very precise. And here's my first take at the question. You might ask, why is there a due process clause in the 14th Amendment at all, given the fact that the Fifth Amendment already prohibits Congress from denying persons life, liberty, or property without due process? Isn't the 14th Amendment's due process clause redundant? The answer is no, because if the Fifth Amendment is incorporated against the states or applied against the states by way of the Privileges or Immunities Clause, the Privileges or Immunities Clause only applies to citizens. So the Fifth Amendment becomes narrowed. It's this majestic promise of due process to all persons. Through the Privileges or Immunities Clause, it's narrowed suddenly only to apply to citizens, because privileges or immunities only go to citizens. The framers believed this promise of due process was so important, it had to be extended again to include all persons, citizens, and aliens alike. So therefore, we see they really were thinking hard about the idea there are certain rights that only citizens get, and that's privileges or immunities, but there are other basic protections that everyone gets, and that's due process of law and equal protection of the law. Now, what does due process contain, and how broadly does it apply extraterritorially? Well, that's a question on which the Supreme Court is divided. Judge Garland, who's been nominated to the Supreme Court as a lower court judge, held that basic rights of due process do not apply to enemy combatants held outside US jurisdiction. But the Supreme Court reversed him in a decision written by Justice Kennedy in the Boumediene case and said that persons held in US prison camps outside of US jurisdiction are entitled to basic due process rights. There was a vigorous dissent by Chief Justice John Roberts. And in Judge Garland's defense, I guess I'll say, it was not clear under existing Supreme Court precedent who was right. So I think Judge Garland, as a lower court judge, was faithfully applying existing precedent. Much more broadly, there was a bigger distinction in the 19th century between citizens and aliens than there is today. Should I take one more beat on this, or
A concise beat would be
concise beat? I think the concise beat will be to say that even liberal heroes today, like Justice John Marshall Harlan, in his Plessy versus Ferguson dissent, said, of course, African Americans shouldn't be subject to railroad segregation. That's an outrage because they're citizens. But Asian American immigrants, fine to exclude them from the United States. Again, it sounds racist today. How could this hero of Reconstruction distinguish so sharply between citizens and aliens? It's because he and other people of his time really did think that citizens and aliens got different rights. In the 1970s, the Supreme Court said that any distinctions based on alienage are inherently suspect. Today, we have a much more expansive and inclusive view, and we don't stress the distinction between citizens and aliens so much. Europe doesn't today, and Europe remains appalled that the US is willing to visit indignities on non-citizens, especially at the airport, that it does not impose on its own citizens. But this debate that you've raised and that you've teed up very well has started at the time of the framing and continues today.
Okay, so we have about 5 minutes left. Let's focus on the 15th Amendment and see what you can do to help put that into context for us.
Nope. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. African Americans finally have the right to vote. Lincoln promises it. He's assassinated as a result. It's really important to remember that the 14th Amendment does not grant African Americans the right to vote. The right to vote is not a privilege or immunity of citizenship. If I live in Maryland and go to Virginia, I can make contracts in Virginia, but I can't vote in Virginia elections or sit on Virginia juries. That's because political rights can't be carried from state to state. That's why I took the 15th Amendment clearly to say African Americans have the right to vote. The story of the effacement and obliteration of the 15th Amendment is one of the other great stains of the post-Reconstruction period. Soon after the 15th Amendment is passed, the infamous Compromise of 1876 essentially says, in exchange for throwing the presidential election to Hayes, who lost the popular vote rather than Tilden, the Republicans are going to withdraw Southern troops from the South and allow the Southern states effectively to deny African American suffrage and to institute Jim Crow. So states adopt a whole bunch of ruses, poll tax, literacy tests, that reduce the rolls in states like Alabama from substantial numbers to essentially zero. The Supreme Court upholds all of those ruses in dreadful decisions, including those written by progressive heroes like Justice Oliver Wendell Holmes, essentially saying, hey, we, the Supreme Court, are powerless to enforce the 15th Amendment. It takes the Civil Rights era, the Civil Rights Act of 64, the Voting Rights Act of 65, meaningfully to guarantee African American suffrage. Today, the 15th Amendment is the source of a great deal of disagreement about new disputes over voting, including voter ID laws, same-day voting registration, and so forth. And we're debating its meaning today. But for Lincoln considered the 13th Amendment a king's cure for the problems of Reconstruction because he thought that abolishing slavery contained implicit in it all of these other rights, but it took the 14th and 15th Amendments to make those rights explicit. And Chief Justice Earl Warren believed that political rights were the most important of all. Without meaningful suffrage, African Americans and others could not defend their own rights. So although I think we can't play favorites among the three amendments, all are significant, it's appropriate that the 15th Amendment was last because it was the culmination of the efforts of John Bingham and Thaddeus Stevens to make Lincoln's promise at Gettysburg a reality and to guarantee civil and political equality to African Americans.
Okay, now listen, we are out of time, and I apologize for that, but Jeff will be here signing books and answering questions if you have them. And for those of you who are here, we're also having an open house across the street at the new House Divided Gallery at 61 Northwest Street. It's an augmented reality studio that shows off what we're doing in the classroom experience today. And for those students who are here from Crossroads Middle School and Carlisle High School and Penn Manor High School, I'm going to take you over first so you can get a chance to see this place. I'm glad you came, and thank you for joining us. Thank you to everybody who came. And let's give Jeff Rosen a warm welcome, warm congratulations.
Thank you very much.
That was excellent. Thank you so much.